Hi guys, here are 5 ways the big beautiful bill makes it easier to sue you and what you can do about it. But before we dissect how the big beautiful bill greases the skids for moral lawsuits, let's go ahead and set the scene. Some of the biggest financial donors on Capitol Hill are from the trial lawyers lobby, quietly writing checks that add up to tens of millions of dollars. And here's the kicker. The people cashing those checks, most of them carry the exact same credential, JD. In other words, most members of the U.S. House and Senate are also lawyers. In fact, roughly half of Congress, plus a hefty share of state legislators, are attorneys by trade. So when lawyers bankroll lawmakers and lawyers are lawmakers, guess whose interests get baked into the statute? Not yours, theirs. So they draft the rules that nudge more disputes into the courtroom, crank up potential damages, and stretch liability like legal taffy because every extra lawsuit is dinner on the table for their profession. More filings, more billable hours, more ways to reach into your pocket. In other words, the game is rigged long before anyone yells objection. So this video pulls back that curtain and exposes exactly what this big beautiful bill changed, and more importantly, how you can fight back. They called it the big beautiful bill. But what it really did was open the door for more lawsuits. And if you've got anything to lose, property, savings, your business, this affects you. Because this bill, it quietly made it easier to sue you and easier to win. So in this video, I'm going to show you the 5 biggest traps buried in this bill that most people missed and how you can fight back. So stick around because number 3 might be the one that turns your assets into somebody else's payday. And hey, if you're serious about protecting your wealth from lawsuits, make sure to subscribe to this channel if you haven't. I'm the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners, and we've set up more Cook Islands trusts than anybody else in the world. I've been doing this for 34 years. So this isn't theory. This is what I see every day, so let's get into it. So what is this big beautiful bill? Now they gave it a pretty name, Consumer Legal Accountability and Fairness Act, but it's really the big beautiful bill for plaintiffs' lawyers, because behind the talk about fairness and accountability are provisions that quietly empower lawsuits. It lowers the bar for filing. It expands liability. It shrinks the tools that people like you and I can use to protect ourselves. So think of it this way. The bill didn't build new roads. It bulldozed barriers. Barriers that used to protect business owners, professionals, real estate investors, people who built something. So let's walk through exactly how. Number 1, expanded joint liability means you pay for others' mistakes. So this bill brings back aggressive joint liability in more civil cases. So what does that mean? Imagine you're only 10% responsible for a situation. You did almost nothing wrong. But if your co-defendant can't pay, or if they're broke, that means you're on the hook for the full 100%. That's right. You could be a minor player and still owe the whole judgment. Here's a real world example. A business owner we worked with was sued in a multi-party case. He was just a vendor, but because the main defendant declared bankruptcy, the court came after him for all $2.7 million. Under previous standards, he would have owed $270,000 at most, but after the big beautiful bill, courts are applying joint liability rules more broadly. It's like a lawsuit version of musical chairs. And if you're the last solvent one standing, you lose. So that's what this bill will mean when they vote it into law. Number 2, lower standards for filing means more frivolous lawsuits. So this bill gives plaintiffs more latitude to file lawsuits without rock solid evidence up front. Now they call it access to justice, but here's what it really means. More lawsuits, less proof, longer stress. Now, lawyers can file suits based on vague claims, drag you through months of discovery, and hope you settle just to make it go away. So that's not justice, that's legal extortion. Now here's a stat. According to the U.S. Chamber Institute for Legal Reform, tort costs in the U.S. topped $443 billion in a recent year, and only 57 cents of every dollar went to the plaintiff. The rest, eaten up by legal costs. It's not about fairness, it's a business. And now it's an easier business than ever. Number 3, asset discovery is now easier for people suing you. Here's one of the most alarming parts of this bill. The bill makes it easier for plaintiffs' attorneys to pry into your finances before the court even determines liability. Just think about that. Before a judge or jury says you're guilty, they can already start asking, what bank accounts do you have? What properties are in your name? How much cash is in your brokerage? So it's like a burglar asking for the blueprints to your home before breaking into your house. And the court saying, sure, here's the key. So you might wonder, can't you just say no? Well, not really. Judges can compel disclosure under threat of contempt. And if you don't comply, you could be facing sanctions or even worse. So that's why we see the best time to protect assets is before anybody files a lawsuit. So once you're under the microscope, many times it's too late. Number 4, public interest loopholes. So what does that mean? That puts professionals at risk. So if you're a business owner, a CEO, director, attorney, or even a landlord, you need to listen closely. This bill reclassifies many private civil actions as public interest lawsuits. Now that sounds noble, but it causes a dangerous implication because you might not be able to get your legal fees reimbursed even if you win. Why? Because courts can now rule that the case served a public benefit even if it was meritless. So you eat the cost. So here's the catch. This provision encourages aggressive trial lawyers to file headline-grabbing lawsuits against professionals with deep pockets. We've seen doctors sued over rare side effects, real estate investors sued by tenants months after they've moved out, even law-abiding employees sued under ambiguous labor laws. These lawyers don't care if they win. They just need the pressure and your fear to force a payout. And if you're forced to pay your own legal fees, you can't get reimbursed for them, you're much more likely to settle because otherwise you'd be out tremendous legal fees. And finally, number 5, trusts and LLCs are under new scrutiny. Now, unless they're offshore, the final nail in the coffin, here it is. The big beautiful bill included companion legislation that encourages judges to pierce domestic legal structures more easily. So domestic asset protection trusts, now it's easier to challenge in court. Single member LLCs, often disregarded completely in lawsuits, so they can't protect you at all. That's what this bill is going to do. So it's a direct attack on the tools that Americans have traditionally used to separate personal and business liability. But here's the twist. Offshore asset protection trusts aren't touched. In fact, when structured correctly, say a Cook Islands trust with a Cook Islands LLC inside of it, these tools are beyond the reach of the local courts. And like I said, we've established more of these than anybody in the world. So let me explain. You're the manager of your Cook Islands LLC. That LLC owns your bank account. It also owns mortgage liens against your real estate, and the trust, your offshore trust, owns the LLC. And our licensed bonded trustee company law firm steps in only when a lawsuit strikes, so taking control to protect the assets. So even if a U.S. judge says turn over the money, you can legally say I can't. So under Cook Islands law, the can't be forced to comply. That's the nuclear shield. And in the big post-big beautiful bill world, you're going to need one. So that being said, it goes without saying that is once this bill becomes law, this is what's being forecast. So here's the cliffhanger. Is this even legal? Now you might be wondering, wait, can you really just move your money offshore? Isn't that shady? Isn't that illegal? Well, we're going to get into that in just a minute. But first, we'll talk about what happens when you don't. Because lawsuits aren't just about money anymore. They're about leverage. They're about fear. And if you don't have a plan, your finances aren't the only thing they'll attack. So here's why the rich don't wait until it's too late. That being said, let me tell you a quick story. A plastic surgeon in California, they came to us in 2019. He was doing well, a $4 million a year business revenue operation. He had multiple properties, he had a savings, the works. So we put together an offshore trust, an LLC structure inside of it, and mortgage liens on the U.S. property. So everything was buttoned up. A year later, a malpractice lawsuit hit. Is a $12.8 million demand, but guess what? His U.S. real estate had been encumbered. We got third-party mortgage companies to purchase the mortgages and put the proceeds from the mortgages in his offshore trust. His liquid funds had moved offshore. His ownership interests were held by an LLC inside the Cook Islands Trust, and the judge couldn't touch a thing. So they dropped the lawsuit. He didn't have to pay a dime. So that's what asset protection looks like. And yes, it's 100% legal when done properly. So what's illegal is fraudulent conveyance, like moving assets to hide them after a judgment is entered. But planning ahead, that's just smart. Now here's what the law allows and why most people never use it. You are allowed under both U.S. and international law to structure your assets to make yourself unattractive to a plaintiff. There's nothing shady about saying, I don't want to be an easy target. In fact, wealthy families have done this for generations, the Rockefellers, the Waltons, and so on. And countless CEOs and entertainers you'll never hear about because their protections worked, and the strategies they use, you can use them too. You don't have to be famous, you just have to be smart and early, because once the process server shows up with a lawsuit, your options shrink fast and they also get more expensive. So what can you do right now? Let's talk about that. Let's recap on what you can do. So before the big beautiful bill catches you by surprise, the big beautiful law, number one, move assets that are at risk into legal structures. So start with LLCs, especially multi-member LLCs, and even better, offshore ones. Avoid single-member, US-based LLCs unless they're wrapped inside of a trust. Number two, strip equity from your real estate. Use a Cook Islands LLC owned by a Cook Islands trust to record lines of credit, mortgages against your US properties, even if you never draw on the funds. And then later on, we can get a third-party lender to buy those mortgages and put the proceeds into your offshore trust. Number three, use trusts for bulletproof protection. Domestic trusts can be pierced. Offshore trusts, especially in the Cook Islands, give you jurisdictional insulation. So we use the Cook Islands, we use Belize for offshore trusts, and we use Nevis. Number four, don't wait until it's too late. The statute of limitations on fraudulent conveyance in the Cook Islands is just 1 to 2 years, depending on the type of creditor, and Belize, there's no look-back period at all. But timing is everything, so it's important to get started now. Number five, talk to real experts. In fact, I've been doing this for 34 years, and if you're serious about this and you have at least $500,000 to $1 million in assets or more, feel free to visit us at assetprotectionplanners.com. You can get a lot more free information. You'll find the tools and the people who can walk you through the process and help you know how to use them. Now let's talk about the illusion of security. A lot of people think, well, I have insurance, so I'm fine. But when the lawsuit exceeds your policy, like that happens all the time, or when your insurer denies the claim, and that happens all the time, that's when people call us in a panic. So it's like trying to put on a parachute after you've already been pushed out of the plane. The big beautiful bill come big beautiful law made the lawsuit game even more aggressive. So your protection needs to be more sophisticated, and that's what I do, quietly, effectively, and legally. That's what we do at our law firm. So here's some final thoughts. Don't just hope, plan. So I'll leave you with this. The people who get blindsided by lawsuits aren't bad people. They're just like you. They're busy, they're successful, they're focused on growing, but not defending. And in today's legal climate, that's a mistake. You don't build a bunker after the bomb drops. You build it in peace so that you're safe when the storm hits. I'm the business guy, and that's what I do. And if you've got value from this video, go ahead and hit the like button. I'd really appreciate it. Share it with somebody who you care about. Subscribe if you haven't for weekly strategies on how to protect what's yours. And when you're ready to take action, if you're serious, visit us at assetprotectionplanners.com. We're here to help.